Friends, let's start it. Otherwise, we'll not able to finish. Last time also we have to then wrap it up early. So I don't want to do that. Today we have to complete our bankruptcy session so that next topic we can take it, which is going to be income tax and GST during insolvency and liquidation. Very hot topic. Lot of confusion, lot of problem. So at that time, again, we'll connect with you. Meanwhile, welcome all. Thanks a lot for your participation. Your overwhelming response is really very encouraging to us for continuing this kind of session. Friends, the intention is sharing knowledge, discussion. We all are equal. We all are learner. Every day we learn. So we request all the participants to raise their query in the chat box. We are here to discuss. No one had claimed to be expert here. So this is the forum for discussion and sharing knowledge. And we have with us our stalwart. You know that Mr. Hemant and Mr. Sanjeev sir. Mr. Hemant is I will just short it his introduction, Hemant, right? If you don't mind. He's a chartered accountant since years. And he is also into audit, taxation, and insolvency professional. He is there as a personal guarantor, insolvency professional. So I have specifically invited, and various areas of practice he is involved as a CA, but as a IP, he is into, of course, CRP process since years from starting age, early starter, and also personal guarantor is also early starter. As regards Sanjeev sir, everyone knows that. If IP doesn't know Sanjeev sir, it's impossible. Then they are not attending webinars and seminars. He's always there, and I'm really thankful, Sanjeev sir, for all your support. Really thanks for that. For 3 webinars with back to back, he's traveling, but he is attending all our webinars and answering. He is having the entire banking experience, I'll say, to name the department in India, outside India, name the department, is that in SBI. He is involved in all the IBC process, setting up system in the SBI, and also empanelling process, and each and everything he is involved in SBI, which is the main bank of our country and having maximum and voluminous IBC transactions. So having very in-depth knowledge, involved in policy making with the governments and authorities. So we have stalwarts with us, and with this introduction, I'll request Ms. Jasveen to start the presentation. Panelists, anytime, as you know, you can intervene and share your knowledge, please. Welcome back here to both Hemant sir and Jasveen and Sanjeev sir. Thanks a lot for your time.
Thank you so much, ma'am. Good evening to one and all present here. It's always a pleasure to be back here and share the little that I know and learn a lot more. So we will begin with bankruptcy process of personal guarantors to corporate debtors. So the legal framework involved in the process is first the MCA notification dated 15th November 2019, wherein the provisions related to bankruptcy of personal guarantors to corporate debtors was made effective from 1st of December 2019. The second is Insolvency and Bankruptcy Code. Section 78 deals with applicability of part 3, that is individual procedure, 79 definitions, and a gamut of sections 121 to 178 deals with specifically with bankruptcy process. Third is the rules, insolvency and bankruptcy, application to adjudicating authority for bankruptcy process for personal guarantors to corporate debtors. We'll refer to this as the bankruptcy rules hereafter. The fourth is the IBBI bankruptcy process for personal guarantors to corporate debtors regulations 2019, notified by the IBBI with effect from 1st December 2019. We'll refer to this as the bankruptcy regulations. So who exactly is a bankrupt? A bankrupt is a personal guarantor or an individual, in this case, personal guarantor specifically, that has been adjudicated as bankrupt. That is, a bankruptcy order has been passed under section 126 against the person. The partners of a firm wherein the firm has been adjudicated as the bankrupt, and a person that is not discharged, that is not a discharge order is not being passed against the person, an undischarged insolvent shall also be included in the definition of bankrupt. Second is the bankruptcy debt. Bankruptcy debt shall include any debt that is owed by the personal guarantor on the bankruptcy commencement date. Bankruptcy commencement date is the date on which the bankruptcy order is passed by the adjudicating authority. Bankruptcy debt also includes future debts, that is, any debts that is being contracted by the bankrupt before the commencement date. However, the liability for the same arises after the commencement of the bankruptcy process, and any interest due pursuant to these two debts. Application process. Who can make an application for bankruptcy? The creditor itself, creditors jointly with other creditors, and third, the personal guarantor itself. The most important point, when can this application for bankruptcy be filed? In case the insolvency resolution, personal insolvency resolution process application is rejected by the adjudicating authority, and the resolution professional in the report has specifically stated that the intention of the applicant was to defraud the creditors or the resolution professional, then in that case a bankruptcy application can be preferred. Second scenario, where a repayment plan of the personal guarantor has been rejected either by the creditors or by the adjudicating authority, as the case may be. And the third is when the repayment plan is actually approved by the adjudicating authority, but the personal guarantor failed to fully implement the same. So the creditors who had not been discharged pursuant to the repayment plan can go ahead and apply for bankruptcy. Time limit, this application shall be preferred within 3 months of the adjudicating authority order. Application by personal guarantor. Personal guarantor's application shall be accompanied by a record of the insolvency resolution process, an order of the adjudicating authority pursuant to which this application has been filed, and the third and most important, a statement of affairs of the personal guarantor, and this shall not be later than 2 days prior to the date of the application. Like we had also seen this in the insolvency process, insolvency resolution for personal guarantors. A statement of affairs includes the record of assets, liabilities, and income of the personal guarantors. So assets and liabilities for 3 preceding financial years, secured and unsecured debts of the guarantor for preceding 3 financial years, finances of the business owned by the personal guarantor, wealth tax paid for the last 5 years, and income statement for last 3 years of the personal guarantor. This application shall be in Form A of the rules along with the fees of ₹2,000. The personal guarantor may propose an insolvency professional to act as a bankruptcy trustee in its application, and a copy of this application shall be served upon every creditor and corporate debtor to which the personal guarantor was a guarantor. Application by creditor. The creditor's application shall be accompanied with record of insolvency resolution process, order of the adjudicating authority, same as in case of the PG. Third is the record of the debt owed by the personal guarantor to this creditor. And last is other information which shall be evidence of debt and default. And if the creditor has any information about income, assets, or liabilities of the personal guarantor, a record of the same with supporting documents shall also be provided with the application by the creditor. So we remember Sanjeev sir had said that in SBI has set up a system wherein they collect the information from creditors, from the personal guarantors regarding all their income and assets. So that would also be required to be attached with the application by creditor. This application shall be in Form B of the rules along with the fees of ₹2,000. A creditor may propose an insolvency professional to act as bankruptcy trustee. In case where a joint application is filed by 2 or more creditors, they may nominate one creditor to act on behalf of all for the purpose of convenience. And a copy of this application shall be given to the personal guarantor and the corporate debtor to which this personal guarantor had furnished guarantee. Now, in case the application is filed by a secured creditor, other than the documents that we had seen earlier on the previous slide, certain additional statements and documents are to be furnished, which shall be a statement by the creditor, secured creditor, that in case the bankruptcy application is admitted, he shall give up the security that he holds against the personal guarantor, or that he is making this application only in respect of the unsecured part of debt and a value, estimate of the value of the unsecured part. So in short, a secured creditor cannot exercise his security as well as file an application. He has to choose one over the other. Effect of application being filed, interim moratorium, like we had also seen in the insolvency resolution process. Interim moratorium shall be operative from the date of filing of application to the date of the order, bankruptcy order. Moratorium shall be against all actions against the property of the personal guarantor. During moratorium, any pending legal action against the...
Jasveen, I think Mr. Venkatraman has raised the hand. Mr. Venkatraman, you want to say something? Mr. Venkatraman? I think by mistake. Yeah, sorry, Jasveen, you can carry on.
No problem. Okay. So during moratorium, if there is any pending action against the property of the personal guarantor, that shall be stayed, and no new legal action can be initiated against any property that is owned by the personal guarantor. Appointment of bankruptcy trustee. If the IP has been proposed in the application itself, the adjudicating authority shall direct IBBI to check if any disciplinary proceeding is pending against such IP within 7 days of application, and then IBBI shall either confirm the appointment or reject the appointment and appoint a new IP within 10 days. Now, if the bankruptcy trustee has not been proposed at all in the application, then the adjudicating authority can appoint the IP from the panel. Bankruptcy order and its consequences. Bankruptcy order shall be passed by the adjudicating authority within 14 days of the confirmation or nomination of the trustee as the case.
Jasveen, it is recommendatory or within 14 days?
Recommended.
Okay, carry on.
Recommended. The adjudicating authority shall furnish a copy of the application and the bankruptcy order to the bankrupt itself, the creditor who had filed the application, and the bankruptcy trustee appointed. This shall be within 7 days of passing of the order. Now, validity of this bankruptcy order shall be only till the discharge order is passed. Effect.
Moratorium also will be up to discharge.
Yes, definitely. Till the discharge, this entire process is only up to the discharge order.
Okay.
Effect of the bankruptcy order. Once this order is passed, all the assets, the estate of the bankrupt, as it is called, shall vest with the bankruptcy trustee. This estate shall be then divided among the creditors, post realization and then distribution, which we shall discuss in the course. And a moratorium shall operate, that is, the creditors of the bankrupt shall not file, initiate any action against the property of the personal guarantor or commence any legal action without adjudicating authority approval. This is the restriction. Effect of the order specifically on secured creditors, other than under section 123 that we had seen, wherein an application itself is filed by the secured creditor, the rights of the secured creditor are not affected by the bankruptcy order. This is only if provided that the secured creditor takes action to realize its security within 30 days of the bankruptcy commencement. This timeline is important for all secured creditors. Disqualification of bankrupt. So once the bankruptcy order is passed.
Jasveen.
Yes.
Yeah. if if the right of secured creditor is not exercised within 30 days, automatically the assets will be vesting to the common pool, and it will be dealt with under the bankruptcy process by resolution professional. So that also has to be noted.
Yes, precisely, sir. Precisely. Then he loses the exclusive right to the asset.
Yeah, that means impact. Yes, thanks for clarifying that. Yeah.
Thank you, sir. Upon the passing of the bankruptcy order, the bankrupt shall face certain disqualifications. That is, he cannot be appointed or act as a trustee. He cannot be appointed as a public servant, cannot be elected to any public office, or cannot be a member of any local authority. So any fiduciary responsibility or involving public nature or public office cannot be bestowed upon the bankrupt. This shall operate up to discharge.
So you have mentioned earlier they cannot act as a director, promoter of the company.
Now that's in the subsequent slide, in the next slide.
Oh.
Yes. Restrictions on the bankrupt. From the bankruptcy commencement date, the bankrupt cannot be appointed as a director or promote a new company. He cannot create any charge on the assets, on its assets, or take any debt, except with the approval of the bankruptcy trustee. He must inform his business partners about the bankruptcy process, and before entering into any financial or commercial transaction, the value of which is 1 lakh rupees or more, he shall inform the other party about his bankruptcy process. Yes, ma'am.
There's a question: how other creditors will know about orders of bankruptcy commencement date who are not applicant?
Yes, so in the next slide, I think absolutely the subsequent slide itself, we have a public notice that is issued.
Yeah, okay.
That is how they come to know about it. I will come to it.
Yeah, Bindra ma'am. See, out of all these restrictions, the most important restriction is he cannot travel overseas without the adjudicating authority's permission.
Yes.
That is the most important, which we try to persuade the bankruptcy person, the person to whom the bankruptcy process is going on. If their relative or close relatives are staying abroad, they are scared because of that particular thing. So we try to tell them, okay, better you put your resolution plan, repayment plan, and get rid of all these restrictions.
Okay.
Cannot have restriction as such. Because if you are not a director, okay, he said I am retired, I don't want to become my brother will become a director, and other reasons are there, but still, they are more scared of this particular reason that they can't travel overseas without the permission of AA. So on that point, we try to negotiate with him.
Okay.
Okay. Thank you. Thanks for input. Yes, this is a very important thing. Nowadays, everyone wants to go out.
And
bankrupt people want to go out very easily.
Yeah, that is the main reason behind which this entire process has been made effective.
But Hemant, don't you think it's really contradictory? A bankrupt person is very keen to go out of country.
Yeah, and I think taking a clue from Vijay Mallya and other people.
So they are so having money, no? That means they are having money. Yeah, please.
Yes, and he cannot maintain any legal action as well in his own name except with adjudicating authority permission. And all these restrictions shall operate only till the discharge order is passed. Okay, now we had already seen when an application is filed by the personal guarantor itself, he has to give a statement of affairs. Now, what if this application is filed by the creditor and a bankruptcy order is passed? Then it will become difficult for the trustee to extract the details of assets and liabilities of the bankrupt. Therefore, to meet this challenge, a statement of financial position has to be filed by the bankrupt within 7 days from the commencement date. It shall be in Form E, and the details to be mentioned are the bank details of the bankrupt, assets of the bankrupt for last 3 years, liabilities, debts secured and unsecured for last 3 years, wealth tax paid, and debts to the associates, or guarantee paid in respect of the associates of the guarantor. Now, the trustee may again require the bankrupt to furnish certain more details. Claims by creditors. Now, this is we will be addressing the question that one of the participants had questioned. Upon the passing of the order, within 10 days of the order, an individual notice is required to be served by the adjudicating authority itself, or it may direct the bankruptcy trustee. In most cases, the adjudicating authority directs the trustee to issue a notice to every creditor. This is a personal notice. Now, how do we get the creditors? It shall be from the statement of financial position that was given by the bankrupt, or as per the application if the application is filed by the guarantor itself. And this shall be in Form D. Plus, additionally, even after this individual notice, a public notice for the knowledge of all the creditors of the bankrupt shall be published in one English newspaper, one vernacular newspaper, and it shall be placed on the premises and website of the adjudicating authority. And this shall be in Form C of the rules.
Just in 1 minute, there is a question.
Yes.
Good evening all. My question is, if there is a CRP wherein there is a resolution plan by which the PG is personal guarantor is relieved of his liability, in that case, can a dissenting creditor proceed against the PG under Section 95? Panel?
May I attempt to answer that?
Yeah, let me answer.
No,
So
let's
basically-
Sure. Yes.
Panel first, please.
So basically, resolution plan, once approved, is binding on all, including guarantors, all creditors, government authorities, everybody. So once you put it in the plan that this also guarantee is also taken care of, then it is a full and final. You cannot go. You have no claim against the guarantee. It is all settled. So that is the
if it is mentioned in the plan itself, yes.
Yeah. And one more thing, even in some cases, we have experience in the bank where we have like assigned the asset to some ARC or some other creditor. There also we have lost the right to go against the guarantor, because unless we retain our right in the plan or in the agreement with the buying party, that we retain the right to go against the guarantor separately. Otherwise, if you assign or you sell the equity as a matter of assignment, then also the creditor lose their right to go against the guarantor. So that is second thing to keep notice.
So can I interfere?
Yeah,
Yeah.
please.
Yeah, because I myself is Josie Stephen. I asked that question.
Please.
Yeah, because as per Section 128 of the Contract Act, surety's liability is independent of the main, principal debtor. So if there is a dissenting creditor and he has all the right to proceed against guarantor separately, right?
No. Yeah. So basically, the idea is that whether it is dissenting or assenting, once the plan is approved, it is binding on once and all, everybody. So there is no distinction once the plan is approved by 66% of the creditors. So that is the cram down. We call it a cram down provision in the code, that it is crammed down on the other dissenting creditors also, that they have to follow. There is no discretion that they can go against.
Sorry.
I will interrupt
But
you.
only escape is that if you retain in the plan, like in SBI, we have format of the plan where we specifically retain, we put these 2-3 clauses in the plan that the bank has suffered so much haircut in this because of this resolution, and bank retains its right to go against the guarantor for the amount of haircut suffered in the resolution. So that is clearly mentioned in the plan. That becomes a court order. Then your right is intact. Otherwise, thank you.
I was adding to, let me add this point, because we ourselves has done this. In one resolution plan, my client were descending creditors, FC. And that's why we objected the approval of plan in NCLT. We filed specific and we objected the approval. We given the reason we given that fraud and all that, but the thing that, and say that they cannot, in the plan it was mentioned that our right of personal guarantee is revoked, and we said we cannot, they cannot do it. We objected, we fought. So for NCLT allowed us our right to file the appeal also against their order, and also our right of going against personal guarantor. So that way we protected our right, and we are filing the case against personal guarantor now. So in this case, you have to intervene and protect your right, then you can do it. We have done this, it's a current case only, and that's why I am telling you this.
Is there any case citation in this regard? Any?
Yeah, I'll provide you. It's
Okay.
present case only.
All
The
right.
order is yet out.
There is no apex court orders in this regard.
No, NCLT Mumbai.
Okay, thank you.
Okay, yeah. Thank you. Yeah, Jasveen.
Yes. Okay. Registration of claim. So the creditors shall file their claim with the bankruptcy trustee within 7 days of the public notice. It shall be in Form 7 of the rules. Now, even if the creditor fails to file this claim within 7 days, there is an additional opportunity that is given under this process as a final opportunity. So you still have a right as a creditor to file it later, but it's always preferred to do it within time. This claim can also be made in respect of future claims, that is where the claim amount is not due and payable on the bankruptcy commencement date, but the creditor has a right to the distribution as per the terms that were agreed to prior to the commencement date between the bankrupt and this creditor. In case of assignment of any debt during bankruptcy, both the parties, assigner or assignee, shall intimate the same to the bankruptcy trustee. List of creditors. Now, on the basis of the application that was filed plus the claims that were received, the bankruptcy trustee shall prepare a list of creditors within 14 days from the commencement date. The contents of this are name of the creditor, the amount of claim that is made, claim admitted, security interest if any, and the reasons for admission or rejection of the claim. Any modification in this list? Yes, sir.
Yeah, one observation here is that, if 10 days are given for public notice and 7 days are given for, claim, registration of claim, so total number of days will be 17 days. How can a resolution professional prepare this list of creditors within 14 days from the bankruptcy commencement date?
Precisely, this thought had come to me even when I was reading it. But so actually, though it says 10 days, we have to do it earlier. Since it is within 10 days, it's actually an earlier timeline to meet this 14 days timeline.
Anyhow, you can go ahead, please. See, this is my observation from the reading of the plain reading of the law.
Yes, that's right, sir. Thank you so much. Thank you, sir. So any modification in the list of creditors can be made within 15 days from the last date of the claim, and the same has to be filed with the adjudicating authority. Now, after the list of creditors is drawn up, within 14 days, the trustee shall give personal notice to each creditor whose name is included in this list for a detailed proof of their debt, along with particulars of debt, security, and proof of interest if they are liable for the same. This proof of security and debt shall be given within 30 days of the notice. If any creditor fails to submit this proof of debt within 30 days and he is a secured creditor, then the trustee, with the prior approval of the adjudicating authority, gets a right to sell the secured property of this creditor. And any mutual credit shall also be mentioned in this proof of debt so that a set-off can be claimed. Meeting of the Committee of Creditors. The first meeting of the creditors shall be held within 21 days of the commencement date. The agenda of this meeting shall be to establish a committee of creditors and any other agenda that the bankruptcy trustee may deem fit.
Their timeline is less, 21 days only.
Yes.
So everything is twist. Yeah, please.
Yes. The notice for every meeting shall be given 7 days prior to the meeting. However, a lesser period, shorter period can also be specified if it is decided by the Committee of Creditors. However, this period can never be less than 48 hours before the meeting. The date, time, venue shall be mentioned in the notice, and a clear option to each creditor to participate in person through video conferencing or through proxy, or vote and as well as vote in person or through e-voting process or through a proxy shall be provided. The notice shall mention agenda. Agenda shall be divided into two: matters to be discussed at the meeting and issues that are required to be discussed and then voted upon by the creditors. And the relevant documents shall be annexed to the notice. Proxy can be appointed under Form B of the regulations, and this shall be deposited by the creditor at least 24 hours before the meeting. Like we have seen in all the processes, the bankruptcy trustee is the convener and shall preside over the meeting. The trustee can decide the quorum for each meeting, and the presence of quorum shall be ensured throughout the meeting. The trustee shall take a roll call and not allow any unauthorized access except with the specific permission of the bankruptcy trustee. The minutes of each meeting shall be circulated within 48 hours of the meeting, and this is a compliance only for the first meeting, that within 3 days of the first meeting, the report of establishment of the committee of creditors shall be submitted to the adjudicating authority.
Jasmine,
Yes, ma'am.
it says determine quorum. So there is no direction that what should be the quorum and nothing.
No, not in the act, neither in the regulations. It only says the trustee shall determine the quorum.
Oh,
But ma'am, actually in the, the earlier that is in the resolution process, repayment process, it is 33%.
Yes.
ah.
Yes.
So we have to have that much at least. But for other meeting, you can fix anything then. But of course, we have to be, of course, judiciary. Otherwise, it will create problem for IPs only. Okay, please.
Voting by creditors. So creditors whose names is mentioned in the list of creditors shall be entitled to vote, except if a creditor holds a debt for unliquidated amount, he shall be restricted from voting, and an associate of the bankrupt shall not be allowed to vote. The voting share shall always be in proportion with the amount of debt that is admitted by the bankruptcy trustee. And in case of secured creditors, he can vote only in regard to the unsecured part of the debt, or if he wants to exercise the right of vote, he shall relinquish his security interest. So all the creditors that are present in the meeting may vote at the meeting itself after discussion of the matter, and the minutes of the meeting shall clearly reflect the name of the creditors that voted for, against, or abstained from voting at the meeting. And for all the creditors who were not present at the meeting or did not exercise their right of vote at the meeting itself, an option of e-voting shall be provided for them. And the voting results of this shall be circulated within 24 hours of the conclusion of the e-voting process. Most important parts of this entire bankruptcy process: administration of the estate. With regards to administration, the bankruptcy trustee has certain functions, rights, and powers. So first function is that he shall investigate the affairs of the bankrupt completely and thoroughly. Second is to realize the estate of the bankrupt and take all relevant steps to do the same, and then distribute the assets among the realization of the assets, or the assets as the case may be, among the creditors. The trustee
Here one observation.
Yes,
Last meeting we had a detailed discussion on this investigation part of it.
Right.
So in the resolution process, the investigation.
Hello, Hemant bhai, you are not audible. Hemant bhai?
I will add my comments here. So basically, there is a basic difference between the insolvency and bankruptcy stay. So insolvency professional is not entitled to do any investigation in the affairs, whereas bankruptcy trustee has given this right. So that's, I think, what he wanted to highlight. So only the bankruptcy trustee.
Yeah. Means like in insolvency,
Yeah.
the RP liquidator has more right.
RP has no, like RP has no right of
here.
investigation, liquidator has. Similarly here, the RP during insolvency has no right to investigate. He cannot do any asset search or anything like that. But as a bankruptcy trustee, he has the right to involve an investigating agency, asset research agency, and then get out of the asset which are not disclosed by the bankrupt, then he can put them in the bankruptcy estate. So
Okay.
that is, I think,
I
what
was
you are.
disconnected. I was disconnected.
Yeah, Hemant bhai, you are, yeah, you can add on. Sanjeev sir has added, but we would like to hear from you as well.
This is about the investigation of affairs. No, I think he's the right person to comment upon it.
He said that only that, that the bankruptcy trustee has a right to investigate it, but not the insolvency professional during the insolvency.
Right. That is what we discussed last meeting. No, somebody raised the point about the investigation part of it when Sanjeev sir has made a remark that how can the SBI can investigate the matter when resolution professionals don't have the power to investigate.
Yeah.
So here in bankruptcy it is specifically provided.
Yeah.
Yes.
Thanks.
So what we have done is that we have found via media that rather than RP doing the investigation, the creditor can themselves do even before filing an insolvency. So why not do a asset tracing of this borrower guarantor, so that when the insolvency process starts, so you can ask the insolvent person to submit an affidavit in his statement of affairs. He has to declare that all the assets mentioned in the statement of affairs are the only asset belonging to me. I have not hidden any asset or not made any, not disclosed any of the asset. If this kind of affidavit is submitted with the statement of affairs, then he is taking an oath under the law, and in case he's hiding something, then you can come out with that asset tracing report and highlight, and then he can be penalized for the perjury of the court. That is what we are doing.
This will expedite and it will be in the interest of each and everyone.
Yes.
Right. Thank you for it. Yeah, Jasveen.
Yes. So rights of the bankruptcy trustee, he has to hold the property, enter into contracts on behalf of the bankrupt, can sue or be sued, enter into any engagements with respect to the estate for better administration of the same, employ persons as he may deem fit for carrying out the entire process, execute powers of attorneys, deeds and instruments, and any other rights that he may deem fit for the purpose of administration. General powers available, he has to sell the estate, and he may issue receipts for any amount that is received by the bankruptcy trustee and recover debts of the bankrupt. Any property of the bankrupt that is held as pledged by any other person shall be redeemed by the bankruptcy trustee. If the estate of the bankrupt includes any transferable assets or securities, he shall transfer the same for money so that it can be realized. And property that is held by the bankrupt as a beneficiary shall be exercised in the same way as if the bankrupt itself is doing so. Controlled by bankruptcy trustee, any property, books, papers, records of the bankrupt that is maintained with the bankrupt itself, his banker, his agent, or any other person shall be delivered to the bankruptcy trustee, and he shall have possession and control over the same. Approval of creditors. The following transactions or following acts can be done by the bankruptcy trustee only with the prior consent of the committee of creditors. Carry on the business of bankrupt, institute or defend any proceedings with respect to property of the estate that forms a part of the estate of the bankrupt. Sale of property where the payment will be received on a future date. There's no immediate payment. The payment would be in future. Mortgage or pledge of any property, or where the estate includes a right or option wherein a certain amount has to be paid to recover back the assets. Then such payment can be made only with the prior consent of the committee of creditors. Refer any debt for arbitration or enter into compromise on arrangements with the creditors itself. And the last is appoint bankrupt to supervise management of estate, carry on the business, or assist the bankruptcy trustee. This can be done only with prior COC approval. Certain duties that the bankrupt has towards the bankruptcy trustee. He shall give all the information of his affairs to the trustee. Whenever the trustee requires his assistance, he shall attend to the same. And if the trustee enters into following transactions after the bankruptcy commencement date, that is acquisition of property by bankrupt, devolution of property upon the bankrupt, or increase in the income. So where the source of income has increased, he shall notify the same to the trustee within 7 days of these transactions. And he cannot part with this income or property except with the prior approval of the adjudicating authority. So now what exactly will be included or excluded from the estate of the bankrupt? So any property that is held by the bankrupt as on the bankruptcy commencement date shall form a part of the estate. The capacity or right of the bankrupt to initiate proceedings over any property. And third is any other inclusions specifically made under other provisions of IBC. What is excluded from the estate? Excluded assets. We had seen the definition of excluded assets in the insolvency resolution process. But just to summarize it, it is the minimum furniture or gold or minimum dwellings that is required for the bankrupt and his family to sustain a minimum livelihood. That would be included in excluded asset. A specific definition has already been given under the IBC. The dues from workmen or employees towards PF, pension and gratuity shall be excluded, and any other asset notified by the central government. As on date, there is no notification in this respect. So all this shall be called collectively as the estate of the bankrupt, and it shall vest with the trustee from the date of his appointment. Now, if the bankruptcy trustee considers it fit, or if a resolution in this respect is passed by the committee of creditors, he may appoint a valuer. The valuer is required to submit an estimate of the realizable value of each asset of the bankrupt. And the trustee may also appoint more than one valuer, and an average of the realization values shall then be considered. Mode of sale of the assets. There are two modes of sale. One is auction, by way of auction. In case of an auction, the trustee shall prepare a strategy and submit it to the adjudicating authority with the progress report that is submitted quarterly by the trustee. This strategy shall include advertisement for auction, information sheet, information about the assets, and notice of the sale that is published. The trustee shall decide the terms and conditions of each auction sale, and the reserve price for the auction shall be the realization value that was determined by the valuer, not prior than 6 months from the date of the auction. But if the auction at this reserve price fails, then the trustee can reduce this price to 75% of the previous price. And if this further fails, then he may reduce the price further, the reserve price further, but with the prior consent of the committee of creditors.
Jasveen, that further reduction, is there any limit like in insolvency, in liquidation? And insolvency, that 75% and that percentage is mentioned, or with the COC approval, they can reduce to any extent?
Yes, so there's only one cap. First level has to be at 75%. Below that, it will be at the discretion of the committee of creditors. There's no capping after.
Yeah.
No cap.
Yes.
Okay.
The auction should preferably be conducted only through electronic means or online portal. But if the nature of the asset is such, or if the trustee feels that he would get a better value for the asset in case of a physical auction, he can conduct the same, but with prior adjudicating authority approval. Second mode of sale is private sale, which is only in case of perishable assets, or where the value of the asset shall deteriorate significantly in case of any delay in the sale. Or third is when the selling price under a private sale is greater than the reserve price in case of a failed auction. In case of a private sale, the trustee shall again submit the sales strategy to the adjudicating authority with the progress report. And the modes or the ways by which private sale can be conducted is either by directly selling it to the potential buyer, or placing it at retail shops, or by any other means that may be considered relevant by the trustee. Realization by secured creditors. Now, the secured creditors that are looking for realizing their assets that they hold as security shall intimate the trustee about the proposed price at which they wish to realize the asset. The trustee shall attempt to find a buyer for a higher price than the price that is stated by them. In case no buyer is found, then the creditor shall realize the asset at least at the minimum price that they had quoted earlier. And if the amount realized from the asset is greater than the amount of the debt of the creditor, then the excess amount shall be deposited with the bankruptcy trustee. Okay, realization of disposition, restriction on disposition of property. The bankrupt shall be restricted from selling or disposing of any of its property between the filing of the application to the commencement date, that is till the order is passed. And if he does so, that sale shall be treated as void. Even if the third party in this sale had acted in good faith, no right shall be created in respect of the property by this third party. So it shall always be null and void. And for this purpose, property shall mean any property that forms a part of the estate, all the property of the bankrupt, whether or not it forms a part of the estate, except where a property has been held in trust by the bankrupt.
Jasleen, can I come in here?
Sure, sir. Sure.
Yeah, so I would like to highlight one thing here, that here in the bankruptcy stage, the bankrupt cannot create any right, or he cannot dispose his property. Whereas in the insolvency stage, till the date of admission, he has the right to sell the property. So that is the difference you have to highlight. So basically, the interim moratorium only applies to the creditors. So creditors cannot sue him, cannot go and enforce their property, but the guarantor, he himself can sell the property. So that is the distinction here. In bankruptcy, even guarantors' rights are taken away. So that is why I want to highlight. Thank you.
Thank you.
And that is why it is given, because insolvency process is a process where the guarantor is provided with an opportunity to settle. So what he can do is he can sell his asset and settle with the creditors, which law thinks that when the guarantor sells himself, he may fetch a better price than rather than RP selling and getting a fire sale or a distress price in the market. So that is why this provision has been kept during the interim moratorium. Okay.
In addition to that, Sanjeev sir, if it is with the malified intention of hiding the assets and all this, it will automatically cashed in Pupe, Mr. Preferential and all this transaction.
But that is the law. Like they have given the provision.
Yes,
on the guarantor, there is no restriction, only on the creditors in interim moratorium and insolvency. Yeah.
Right.
Thank you.
Thank you. Thank you, sir.
Thank you so much. After acquired property, that is, if any property is acquired after the commencement date by the bankrupt, then this shall form a part of the estate and the trustee shall have claim over such property, except if such property is an excluded asset or acquired after the discharge order, then no such right shall be given to the trustee. The trustee shall give a notice to the bankrupt within 15 days of this acquisition coming to his knowledge. This notice can be given even after 15 days, but with prior adjudicating authority approval. And the bankruptcy trustee shall not be entitled to claim this property if the third party had acted in good faith and had acquired this property. Onerous property, the meaning of onerous property is any unprofitable contract or any property of the bankrupt which is unsellable or not readily sellable. The trustee shall have a right to disclaim this property from the estate. It shall require prior COC approval, and the trustee shall be required to notify 7 days prior to the notice that he intends to disclaim this property. And the notice shall be served. This is the notice of disclaimer. The notice of disclaimer shall be given to the bankrupt or any other person who might be interested in this property. And it shall also be filed with the adjudicating authority within 3 days. The disclaimer notice shall specifically state that the right of the bankrupt with respect to this property and that the trustee shall hereafter not be liable for this property. And the notice, if in case Any person who's interested in the property writes to the bankruptcy trustee to decide whether a property is disclaimed or not. And the trustee does not reply to the same within 7 days of the date of the notice from the interested person, then this shall seize the right of the trustee to disclaim this onerous property. Disclaimer of leasehold property, no disclaimer of leasehold property unless these following conditions are met. Service of notice of disclaimer to the bankrupt and any person interested, and no application has been filed objecting this disclaimer within 14 days of the notice. And even if an application is filed, the adjudicating authority has then directed that this should be disclaimed. Any challenge for disclaimer of onerous property or leasehold property can be filed before the adjudicating authority by a person who claims interest in the property, who has certain liability in respect of the property, or in case this property is a dwelling unit, then a person who occupies or is entitled to occupy this property. In this case, the adjudicating authority may also pass an order to vest the property in the applicant itself. Now, since the time is limited, same as in case of CIRP and liquidation, that is the corporate process, we have undervalued, preferential and extortionate credit transactions. They have the same meaning assigned as in case of the corporate process. The look back period for it would be in case of undervalued transactions 2 years before the application date. For preferential transactions 2 years in case of an associate, and in case of any other person it shall be 6 months prior to the date of application, and for extortionate credit transactions 2 years prior to the date of application. So the bankruptcy trustee shall identify these transactions and shall file an application with the adjudicating authority in respect of the same. The adjudicating authority may declare these transactions to be void, or may reverse the position, that is execute a position as if these transactions have never been executed by the bankrupt, and may pass any other order that the adjudicating authority deems fit.
Yeah. Previously, these transactions were, supposed to be 2 years prior to the date of commencement of this proceeding. It has been changed later on that it will be effective from 2 years prior to the date of application.
Mm-hmm.
Yeah, before application, because it takes time, and that's why they wanted application.
Yes. Right.
Thank you, sir.
There is a question whether Pagdi property is considered by BC.
Yeah, I think there are, some intangible rights in the property. So if these rights can be encashed, be utilized for the purpose of, bankruptcy proceeding, definitely it can be, I think.
If you get value of anything, you have to realize the value.
Obligations under a contract. So where a bankrupt has entered into any contract before the bankruptcy commencement date, the party to the contract can apply to the adjudicating authority, specifically requiring the bankrupt to discharge his obligations under the contract or pay damages for non-performance. Continuance of proceedings, even if the bankrupt faces a death, the proceedings of bankruptcy shall continue.
Mr. Kapadia had certain question, I think. Yes, sir.
Yeah.
Himanshu bhai, you have some question? You raise your hand.
Yeah. Can you hear me?
Yeah.
See, with reference to the Pagdi property, if the property is in the possession of a guarantor, then how we can claim Pagdi rights, because he is already staying in that particular property. Then do we have a right to ask him to vacate?
Himanshu bhai, I think, if it is if we can prove that this is a forming part of the excluded assets, and it is falling within the meaning of that excluded assets, then I think he can definitely have a good case.
Yeah, because he's staying there, he's utilizing for his own purpose, so that excluded asset.
Okay.
Okay. Yeah, Jasveen.
A distribution of estate. For the purpose of bankruptcy process, the trustee shall open a bank account in a scheduled bank. The name of the account will be the name of bankrupt followed by in bankruptcy process, these terms. and all the money that is realized by the bankruptcy trustee shall be deposited by next working day. The maximum cash that a bankruptcy trustee can hold is 10,000 rupees, or if he wants to hold higher, then it will require prior adjudicating authority approval, and this shall be for the purpose of meeting bankruptcy process costs. Any payment that is made that is amounts to more than rupees 5,000 shall be made only by way of checks or online transfers. Before the entire estate of the bankrupt is realized, if the bankruptcy trustee feels that he holds sufficient funds in his hand, he may declare and distribute something what is called as an interim dividend to all the creditors whose debt has been proven. A notice of this dividend shall be circulated, and it shall state the amount and the manner of distribution of interim dividend. But before making any distribution of interim dividend, the trustee shall make provisions for certain amounts, which is debt of a person wherein the trustee feels that since he stays at a farther place, he did not have sufficient time to tender or establish his claim, or whether debts have been claimed but not yet been determined by the trustee, or whether disputed proofs, the proof of claim or the debt is disputed. And last is for the expense for administration of the estate. So all this is to be provided for, and then the distribution has to be made.
The first one is really some confusing. That's a person who due to distance didn't. So you don't know the kind, how many people will be there.
Right. So again, the wisdom of the same is with the trustee. If he feels that they'll stay away and they may not have the time to tender.
IP will wish we can give this kind of dividend, interim dividend in bankruptcy. We should have that kind of case. So rich. Thanks. Go ahead.
Right. Distribution of property. So the property of the bankrupt can itself be distributed without realization, but this will require prior COC approval. And the second condition is the nature of the asset should be peculiar in nature, that it can actually not be realized, or even if it can be realized, it will not be profitable to do the same. And a prior COC approval shall be required for each such distribution. However, if the approval is not granted before it or not seeken for by the trustee, then the COC has a power to ratify the act of the trustee if they believe that the trustee had acted in urgency and the ratification is sought in a timely manner by the trustee. Final dividend. Now, after the estate of the bankrupt has been realized, or so far as it can be realized has been realized, then the trustee shall give a notice of intention to declare a final dividend, or a notice that no further dividend shall be declared with reasons as the case may be. Notice shall be sent 30 days prior to the date of distribution. Contents of the notice shall be the proposed date of distribution of dividend, creditors that shall be entitled along with the amount that will be given to each creditor, further details required from creditors if any. Here we get the last opportunity to creditors to submit and establish their claim. A last date will be mentioned in the notice as a final opportunity to submit your claim, and a statement that no further dividend will be declared. Now, after the final date that was given in the notice has been achieved, the trustee shall make a provision for bankruptcy cost and thereafter distribute all the amount that is available to the creditors whose debt has been proven without making any provision for any other creditor. This is important. Priority of payment, waterfall process as we call it. First, the order of the payment shall be first the expenses of the that has been incurred by the trustee for the process shall be provided for. Second is workmen dues for 24 months prior to the date of commencement of bankruptcy and the debt of secured creditors. Third priority shall be given to the dues of the employees 12 months prior to the commencement date. Fourth is dues of the central government and state government 2 years prior to the date of the commencement. And last is for the other dues, which shall include unsecured debt. Now, in case any creditor has given indemnity or made any payment to recover the asset of the bankrupt, then in that case, adjudicating authority may give a special priority to this creditor. And last is, if any surplus amount remains after this distribution under waterfall, then that should be appropriated towards payment of interest during the bankruptcy process.
So this creditor has to apply to adjudicating authority to get special priority, right?
Yes.
So one has to be clear. Okay, fantastic.
And if the trustee has the knowledge of it, the trustee can also do so.
It can do so without.
Yes, there's no specific mention as to who can apply. It's just that adjudicating authority order should be passed for the same.
Yeah, but then the adjudicating authority order is required to change the priority. No?
Yes, yes.
Not that trustee themselves can.
No, not themselves, not themselves.
They can file it to adjudicate.
Yes, precisely. They can file an application with the adjudicating authority.
Okay.
Completion of administration. So after the entire administration and distribution process is completed, the bankruptcy trustee shall convene a last meeting of the committee of creditors, wherein the COC shall be provided with a report of administration of the estate in the meeting. Now, this shall contain how each asset has been sold and how the distributions have been made. The COC shall be required to approve this report within 7 days of its receipt. Now, while distributing the estate of the bankrupt, the trustee shall provide for this amount as well for the last meeting. So any expenses that he would incur for calling this last meeting shall also be kept aside by the trustee. And once the report is approved by the committee of creditors, the bankruptcy trustee shall finally be relieved of his duties. The trustee shall apply to the adjudicating authority for discharge within 7 days of approval of the report by the committee of creditors, or on the expiry of 1 year from bankruptcy commencement date. So in short, to conduct the entire bankruptcy process, a timeline of 1 year has been provided. Adjudicating authority shall pass a discharge order, and a copy of the same shall be filed with IBBI. Earlier completion of administration. So upon filing of the preliminary report, if the trustee feels that the realization from the asset is not enough even to meet the process costs of bankruptcy, and where the affairs of the bankrupt are not required to be investigated, that is, there are clean affairs, no fraud, no further investigation required, then in that case, they can apply for an early completion, early discharge order with the adjudicating authority. The effect of this discharge, the bankrupt shall be discharged from all its bankruptcy debt except excluded debt and debt that has been incurred by way of fraud by the bankrupt after the discharge order has been passed. And this discharge order shall not affect the functions of the bankruptcy trustee or the operations of the sections of IBC. Last important, really important part is the reports that are filed during the entire bankruptcy process by the bankruptcy trustee. First, the preliminary report required to be filed within 90 days of the commencement date. It has to be submitted to the adjudicating authority, committee of creditors, and the bankrupt. So what shall be the contents of this? The position of statements, statement of the assets and liabilities of the bankrupt, plan of action as to how it will go ahead with the administration, which shall include the cost that would be incurred and the timeline for it. Third is the inquiry into the assets and liabilities and income of the bankrupt that is required to be made in the process, and details of the assets that are intended to be realized, which shall include value of the asset, mode of sale, and expected amount realization of the asset. It shall also provide for assets that are excluded from the estate. So this is the first report that has to go. Second is the progress report. As the name states, it is a continuous report stating the progress in the entire process. So it is required to be filed within 15 days from the end of each quarter. And if a bankruptcy trustee ceases to be the trustee, then within 15 days from such cessation. Contents the professionals that are appointed by the trustee during the process, progress in the process, which shall include any dividend distributed, change in the value of the assets during the course, realizations made, process costs incurred, property that is still required to be realized by the trustee, list of creditors of the bankrupt, and a separate asset sale report shall be furnished, wherein value of the asset that is being sold shall be mentioned, the buyer of such asset, and the mode of sale. All these three have to be mentioned in the asset sale report. Any fee due to or received by the bankruptcy trustee during that quarter shall also be mentioned. Now, if this progress report is after the end of the financial year, that is, in case of 31st March, the report that is filed on 15th April shall be enclosed with the audited accounts of receipts and payments. Final report with the discharge application, the trustee shall file the final report, which shall contain the manner of realization of each asset, dividend distributed, discharge of the bankrupt from all its debts, unclaimed dividend, if any, surplus dividend, if any, and last, where the process cost exceeds, the process cost that was actually incurred exceeds the estimate of cost that was submitted in the preliminary report, then specific reasons for the same has to be provided by the trustee. Non-cooperation, so the following person shall extend cooperation to the bankruptcy trustee during the process: bankrupt, his creditors, his employees and workmen, the partners of the bankrupt, auditors of the bankrupt, and any professional that is appointed by the bankruptcy trustee during the process. The resolution profession who had handled the insolvency resolution of the bank of the personal guarantor, the insolvency resolution, interim resolution professional, and liquidator of the corporate debtor to which this personal guarantor has furnished guarantee, and any other person who is in possession of the property of the bankrupt. If any of the above enlisted persons fail to cooperate with the bankruptcy trustee, he can make an application to the adjudicating authority for directions. With this, we come to the end of this process of bankruptcy.
Thanks.
One observation here.
Yeah.
Section 144 is prescribing the offenses and penalties, and in that there is a punishment for false information, etc., by creditors in insolvency resolution process, where a debtor or creditors provide information which is false in any manner, the material particular with the resolution professional, he shall be punishable with a imprisonment for a term which may be extended for 1 year, or with the fine, which may be extended to the rupees 5 lakhs. So section 184 is, so you definitely try to educate your the person, that any false information or anything, which is there is a this kind of stringent penalties. So they have to be careful while sharing the information.
Yeah, thank you for input, Hemant. I think there is no more question to be answered.
I have one question to Hemant,
please.
if you allow. Huh?
Yeah.
No, Hemant bhai, good evening. Just wanted to understand between Lalit Kumar Jain case in Supreme Court and the latest Mahendra Kumar Jajodia. The thing earlier, once your CIRP is complete, then you have the remaining haircut to go to the personal guarantor. And now, when in the SBI and Mahendra Kumar Jajodia, it very clearly says that the CIRP can directly go without the going into the CD. So it is probably much more easier in the sense more options for the creditor. I was not sure whether I understood it since I'm not an expert. So if you have more brief on
can you see, actually my internet connection is not stable. I could not hear the last part of it.
No, I said that in the second case which came recently 2 weeks before.
Yeah, in Jajodia's case.
Yes. So where they say that even without going through the CIRP of the CD, directly go to the PGE. And so I was not sure whether is it a contradiction of Lalit Kumar Jain case, or it is like because the creditor has much more avenue in order to recover from this, looks like. So wanted your view
No, sir.
on it, that's all.
No, sir, I will tell you, in Jajodia's case, they have deliberately discussed the Lalit Kumar Jain's case, and they have distinguished it from, by saying that in the Contract Act, you have the contract with the personal guarantor as well. So you can definitely go to personal guarantor for the debts, and there is no need, for CARP because it is a separate contract, I think. It is what the, if I remember.
But the
That is what the
default has still
conclusion
to
was.
be, the default has still to be established, right?
No, basically.
Yeah, but please, Sanjeev, sir.
Yeah, can I come in?
Yes, sir.
Yeah.
Yeah.
So basically, the idea is, I think one gentleman says that in Contract Act, the creditor has co-extensive right to go against the guarantor and the borrower. So it is not that you go against the first ones and the second later. So it is the choice given available to the creditor to proceed against the guarantor first and the CD next, or CD first and guarantor next. So this was made clear in the Jajodia judgment. In Lalit Kumar Jain, basically what the court has tried to explain is that even after the resolution plan is approved, it doesn't mean that the entire loan is settled and the guarantor goes scot-free.
Yeah,
so the bank have the right to go against the guarantor for the haircut. That was the, because many of the applicants there, they were litigating on this point. Okay, once the case is settled, like in under Contract Act, if you settle with the bank, with the CD, the guarantor goes free. After that, there is nothing, no claim again. But the court said no. Resolution plan is not a settlement. It is the revival of the corporate debtor. So whatever haircut the guarantor, the creditors suffered, they can proceed against the guarantor. In Jajodia, what they have clarified is there is no need to have a CRP initiated first, then only you can go to it. That is the point. So you can go against the guarantor first. Only point is that you will file in DRT. If you go as the guarantor first, then DRT is the adjudicating authority. Later on, if the CRP start, then both the cases can be sent to NCLT.
Okay, yes, sir.
Good. Thank you. Thank you.
Thank you, sir. Thank you for clarification. I hope now there is no questions, so we can.
But sir, one question: DRT notification is not yet been declared because DRT is still not functional in terms of PG.
Yeah, and
there NCLT as per section 60, NCLT has been given the authority of DRT. And
I have come across cases where DRT have admitted this.
Yeah, but I don't think it is. I mean, if I am correctly,
Sanjeev sir, the case which I filed day before yesterday is before NCLT only directly personal guarantors case, without initiating any CRP with the corporate debtor. So the authority is now NCLT. That is what the available information, because I also had a little bit question in this regard, so I discussed the same with the advocate, and then subsequently it has been established that ultimately NCLT has got a power to admit the cases directly to personal guarantor instead of DRT.
I think the question here is the section 60(1) where still there is some confusion. So it is yet to be clarified. So I have seen cases admitted by DRT also, even NCLT also. So this clarification is yet to come. So I think at some stage IBBI should clearly define.
This Jajodia case is exactly NCLT, LAT. It is the manner, and 61 they have already. It has been already accepted by NCLT.
No, but Jajodia, I think already CRP was ongoing. No, Jajodia was not that case where. First,
it can be discussed in this case.
Yeah, but again, that is still a confusion, not yet clarified. So still, I think, because I also spoke to various lawyers, including Mr. Makija and others. So they are still of the view that if the CRP is not yet initiated, so the case has to be filed in DRT. See, fundamental of this provision is that in case you have a CRP pending and you have a IRP to be initiated, so the law wants both should be clubbed together so that a comprehensive resolution can be found, which I think very few lawyers have understood. The purpose here is that why don't combine the two resolution plans? the one plan of the CD and the repayment plan of the guarantor can be clubbed together in the same NCLT. That is the, I think, intention of the law. But
right, but
same time,
while discussing with the advocate of trilegal, they said they have already filed the same case with the DRT first, but they said that it is now clarified in their judgment, so you better directly go with NCLT for filing this particular matter. So that discussed with.
I think we have to wait. Let's see. Any case admitted, then first class. That will be fine. Whether DRT or NCLT, that will prove.
Yes.
Okay. Okay. Thanks, Sanjeev sir. Thanks a lot.
Thank you.
And Hemant bhai, thanks. You have given so much time, both of you, for all these 3 sessions. Thanks a lot. And today we are completing this entire bench session of 3 consecutively on the personal guarantor. Thanks everyone, and we will come back with another session after 15 days. Thanks a lot. Thank you.
Thank you.
Thank you so much.